pursuit of higher education, you all intersect with intellectual property every day. And just to make clear, there's different kinds of intellectual property. Copyrights is what I'm going to be focusing on today. There's also trademarks that protects logos like the Nike swoosh. It protects brand names like Crest or Colgate toothpaste, those kinds of things. Gallaudet University, the name of the institution, is a trademark. But that's a whole topic unto itself. And for the day-to-day of what you do, copyright is really central. There's also patents and trade secrets. I'm not going to cover those today, but my colleague Robert is coming in 2 weeks, and he will be talking about patents when he comes here. Now, I think everybody has a pretty instinctive sense of property. You have a house, a car, a computer. That's tangible property that you own, right? And you can sell it, you can buy it, you can give it to somebody. So intellectual property is another kind of property. It's property that comes out of the creative intellectual process in your head. But once it is created, you have rights in that. There are legal protections that you, as the creator and owner, have in that intellectual property, just as you would in a car or a house that you bought. So today the goal is just to give you an overview of how copyright law works and how it protects the things, the creative works that you create every day here. And now before we dive into the law, I wanted to set up a couple of hypotheticals that I hopefully will relate to what you do, especially because we have an art teacher here, and this is, you should put your name in here. So hypothetical, you can take a minute to read. So Professor Smith wants to use these images in her classroom when she's teaching her students art history. So the first thing she's going to do is put them into her PowerPoint presentation, just like I've put them in here today for teaching all of you. The next thing she's thinking, well, that was helpful. I want to make it available to the students. Now I'll just put it up on the Blackboard course management software system for everybody to access there. And then the last thing she's thinking, well, that went so well, I think I'll put it into the art history textbook that I'm writing. I'll just put those images in there too. So we'll, as we go through, try to unpack in your head what questions might arise under copyright law as you're thinking through all the different things she wants to do with these images. And I want to take a minute to talk about what they are, because that affects how the copyright law works. So the first image here, I'm sure a lot of you recognize, is Van Gogh's Starry Night, created sometime in the 19th century. Second is Andy Warhol's famous silkscreen print of Marilyn Monroe, which incorporates his painting on a photograph taken by someone else. And the last is the Sydney Opera House in Sydney, Australia. Okay, now all of these scenarios and questions relate to me, the instructor or student, wanting to use someone else's work, either Van Gogh's or Andy Warhol's. Here's hypothetical 2, dealing with works you create. Individual, whether it's faculty or student or graduate student or staff, that can have an effect on copyright ownership. Second is all the content that's being used to create this app. I mean, the team is creating the live stream, but you're using this television footage. And so what here is protectable? And at the end of the day, who's going to own whatever it is you created? So we'll dive in, and the first thing we want to talk about is what does copyright protect? Because not everything is protected by copyright law. So here's the legal language. Original work of authorship fixed in a tangible medium of expression. What does that mean? So, original means you came up with it yourself. You created it. You didn't copy somebody else's. It has to reach a certain minimum threshold of creativity. The court looking at this, they're not going to judge if it's good or bad art or music or games, but it does have to have a certain level of creativity to it. Tangible medium of expression. So, everybody's watching. You're you're about to see something performed for the first time. This is my horrible dance, which now is gone forever. You saw it here. I'm sorry if it's trapped in your memory forever, but unless it was filmed, oh my gosh, it is being filmed. So now it's fixed. Right now it's an intangible medium of expression. It's been filmed. If I could confiscate that and erase it, I would, but I can't. So now it's fixed. Had we not been filming here today, and I had just performed that for you, it would have been gone and over, intangible, never fixed, therefore not protected by copyright. Okay? So if I do live performance like that, unless it's fixed somehow, filmed, recorded, put in a book, printed, it's not protected by copyright. So, rule of thumb, if you want to translate this into more English instead of like legalese, any creative work with some degree of originality, and it's written down, recorded, or digitized, then it's protected by copyright. Here are all, yes?
You mentioned it's to be tangible. A video in this case isn't tangible, right? The internet isn't tangible, so how does that tie in?
So it is, it's a good question. In the sense that it is recorded and can be called up again and copies made from it, it is tangible. Intellectual property, it has to be captured in some way that it can be reproduced, basically. Before the internet, it had to be physical, right? But now it's not ephemeral. It's not, a live stream is gone. A recording is captured. That's the distinction. So the kinds of works are very varied. We have architectural plans. Now note, the building itself is not what's protected by copyright. I can go outside and take a photo of any building here on campus, but the architectural design of the building is what's protected. Musical recordings. And in music, we always have two works. We have the underlying composition that the composer wrote, and then we have the recording made by the musician of that song. Movies, again, something that incorporates lots of copyrighted works into it. A movie is copyrighted, so is the script, so is the soundtrack, so are the actors' performances that are captured there. Books, as well as magazines and journals and all kinds of written works that get published. Plays, musicals, Hamilton. And if you think about Hamilton again, you could break that down into many copyrightable works. You have the lyrics, you have the choreography, you have the staging directions, and you have the program itself, which arguably is a printed work that copies are made of. And then in the digital age, we have software code, apps that are designed, websites, all of those are protected by copyright law. Sometimes there's options for patent protection of these if there's a certain method captured in them, but the coding, source code and the object code itself is protected by copyright because it's letters and numbers. So what does copyright law not protect? So unfixed expression, what we talked about, that dance that I hope is not seared in your memories forever. Ideas. So the idea that's in your head, that you're thinking about, that we're speaking about, until you write it down, express it somehow in a tangible way, it's just an idea. It's out there. If somebody else comes up with that idea and you haven't actually put it down in some way in writing or somehow captured it, that idea is there for the taking. Anybody can have an idea. You can't copyright an idea, only the expression of the idea. Facts. Things like dates, historical dates and events, scientific E equals MC squared, equations, numbers, all of those are considered facts that are either discoverable or findable, and so they're not, because you're not creating it, you're finding it, it's not protected by copyright law. And this can be frustrating if you're in a field where you encounter this because you spend so many hours, so much time on your work in this area, and you're thinking, but I put in all that effort. But copyright doesn't come because you put in a lot of effort. It has to be that kind of creative work. That's what determines if it's protected. Also, not protected by copyright law are works in the public domain, like the plays of Shakespeare. So the easiest rule of thumb is that anything published before 1923 is in the public domain. It's been there long enough, no more copyright protection. So think back to Starry Night by Van Gogh, that's public domain, that's there for the taking. Once you get past 1923, it gets a little trickier. So I'm going to jump ahead to the current law, which is after 1978, which is when the current copyright law went into effect. Anything you create and put in a fixed format is protected by copyright law for the life of the author, plus 70 years. So it's my lifetime, my kids, my grandkids. It's protected through that whole time. Where we have a murky gray area is between 1923 and 1978. And the reason is that during that time, US copyright law changed several times. The terms got longer. There were different rules about getting that protection. Nowadays, registration is optional, though a good idea, and I'll talk about that. Back then, it was required. If you didn't register it, you didn't get copyright protection. So if you are trying to figure out if a work you want to use is in public domain or not, and it's from between 1923 and 1978, you'll have to do some more research. It's not an easy answer. And a couple of resources I point people to, the main one is if you Google Cornell copyright, there is a chart where they lay out the different options, whether it's published or unpublished, registered or unregistered, the dates, whether it's protected and until when, because that changes. So that's the first place I always go if I'm trying to determine the copyright status of a work. Also, Stanford University came up with a renewal database where they checked if works that were initially registered were properly renewed. That's really for just books and journals, but that's a place to check whether those are still under copyright. Other things that are protected are government works. Now, obviously, the Constitution is old enough, it would be public domain anyway, but anything the government puts out, whether it's statutes or regulations, anything from any of the departments of the government, reports, findings, those are all public domain. You don't need permission to use those. NASA, any of those things are public domain. And then here's just one more example of the kind of facts. Something in a phone book. It's just organized. It's a bunch of list of names in alphabetical order. There's nothing inherently very creative in that, and so it's not protected. So these kinds of directories are not protected by copyright. Okay, so let's assume you've gone through the analysis of something you created, and you say, yes, this is protected by copyright law. What does that mean? What does that get you? So there are 5 rights of the copyright holder. Number 1, it's in the name, right? Copy, the right to make copies. That I can take my PowerPoint presentation today, make 100 copies on the Xerox machine, and hand them out to everybody. Or I could choose to go sell them if somebody's willing to pay me for all those copies. So that's part of copying then is the distribution right. The second right is not only can I make copies, I get to distribute them how I want to. So that could mean selling them, that could mean giving them, could be putting on the internet if I want people to find it there. But I, as the copyright holder, get to decide where and how my work gets distributed. And if I don't want to distribute it at all, that's my right too. Third right is derivative rights. So this is the right to make something from that copyrighted work. And the example I'll give here is The Grapes of Wrath by John Steinbeck. A derivative work would be to translate that into another language. So if I'm the copyright holder, if I'm the author, say, I wrote the book, I get to decide I would like to license this to be translated to another language. I still own the book. Now somebody else, though, has the right to create that translation. Unless we work out something different, they will own that translation, even though I own the underlying work. And then for other kinds of works that are of this nature, if it's a work that has to be performed, then I, the copyright holder, get to decide when and where it's performed. So you see there Alicia Keys, singer-songwriter, she gets to decide when her works are publicly performed for the first time. Similarly, in art, the artist gets to decide where and when the work gets publicly displayed. And so in copyright law, people often talk about publishing the work, and publishing is a word most of us think about in terms of books and publishers, but in copyright law, it just means making the work available to the public. Okay, so that's what the copyright holder can do. Who is the copyright holder? So let's start very simply. Georgia O'Keeffe, painter, one person creates a work of art. She is the copyright holder of that work. Now we have John Lennon and Paul McCartney, songwriting team. They jointly created their songs. So they become what's called the joint authors. So if you have more than one copyright creator in a work, they jointly own it. Now you might say, well, who owns what part of it, right? analogy I like to use is it's like putting cream in coffee, and once they're mixed together, you can't separate them out. So as many contributors as you have to a joint work, they are all the authors of that work, and therefore, they are all the joint owners of that work. And when we get to licensing later, it basically means if I have contributed, well, along with a team of 7 to a work, I can then choose to license it out to other people, even without my co-authors agreeing to it. I do, however, have to share any monies I make from that licensing with my co-authors, so they get to benefit from that. Okay, now this is still authors creating works individually. But let's think about a company like Apple. So if I work for Apple, and I create something at Apple, who do you think owns it? Apple. Exactly, the company owns it. So if I am an employee of a company, and I create something as an employee of that company in the scope of my employment, it belongs to the company, right? And so anything I would create at Apple would belong to Apple. Sometimes questions arise in places like Silicon Valley because people there are creating all the time, and sometimes they're doing it in their garage after hours, and that's where some of the greatest innovations come from. And there have been a lot of controversies as to when are you crossing the line between what you do as an employee and when are you doing something on your own, when it all kind of ties into what your knowledge base is. And the answer is really, it gets worked out in employment policies and intellectual property policies and in employment agreements. And that's especially important in a university setting like this, where we have professors like Professor McGonagall at Hogwarts, in Harry Potter Land, or Professor Frink on The Simpsons. Sorry, question?
So what comes up more often? So who would you pay more if you were to create that work? Would it be the company or the creator? If you started coming up with an idea on your own, or if you created a company and then you were selling something, who ends up getting paid more?
If you create it on your own, then you own it. If you create it while working at the company owns it. If you create it and then sell it to the company or convey it to the company, it's going to be what you two agree on. You have to have some sort of contract. And it might be that you convey all the ownership to them, or you might convey it but say, I get 10% of whatever you earn on this. So that gets negotiated with the company if you sell them your invention or your creation. License it to them. So I want to talk briefly about the reason ownership and why intellectual property policies are so important in universities is because you are not like typical companies where the employer automatically owns everything you create. In university setting, first of all, we have students, right, who are not employees. So anything all of you create while here still belongs to you. The university does not get an ownership stake in what the students create because they're students here. They're not employees. Now that, if you are working administratively, for the library, that might be different because then you're there as an employee. But as students in the classroom creating things, you own those works. In addition, you have professors. Yeah. And what's interesting is that professors are employees of the university. However, in academia, we have what's called the academic tradition, which is that professors own their scholarship. They might work at one university, they move to another, but the understanding is always, if I write a book, I own that because it's my intellectual property. And so most universities work out a compromise where they say, yes, technically under copyright law, where we employ you, we would own what you create. But we will respect the tradition, the academic tradition, that professors and intellectuals create their own works and own their own works. And so that's what you build into the policy, that we say we are going to have a policy where we're not going to just go by what copyright law says, we are going to respect these intellectual property rights of faculty, of graduate students, and students. And that's why working on policy is so important. Where it can be a little trickier, I think, for professors in particular, is that if it's a book or an article, I think everybody's pretty clear that belongs to the professor. Once you get into course materials, that can be a little harder to distinguish because on the one hand, it might be tied to your scholarship. If this is a graduate seminar, that's very closely tied to your research. But if you're teaching introductory calculus and you use the same curriculum across the whole math department, likely you're not creating very much, and it might be that in that case it makes more sense for the university to own it. they are arguably investing a lot in this creation. And that's another place where you want to have a policy or have contracts that maybe will apportion ownership a little differently, because that is kind of crossing that line. Okay, so this relates to your question. How does ownership of copyright change? So basically, for me to take my copyright and give it to you, we have to do what's called an assignment. And it's literally something we sign. It has to be in writing. And it says, I own this, just like if I sold you my car, we want to put that in writing. In the same way, we will say, I'm going to assign my rights to you. Another way you might do it is through a work for hire contract. So that's similar to being an employee, but for example, I might hire you to design a website for me. And we put in the contract, anything I create for you, you will own. Even though I'm the creator, I'm conveying ownership to you under this work for hire agreement. The other main way that copyright gets transferred is through inheritance. So remember we said it's life of the author plus 70 years. So when I die, my copyrighted works go to my heirs. And if I have spelled it, I can spell it out in my will. Sometimes people want to leave them to an institution. Famously, the author of Peter Pan decided to convey his copyright to a hospital, a children's hospital in London. So all the proceeds from that book benefit the hospital rather than an individual. But in most of the time, it will go to your children or your wife, your spouse, and so on. All right, now the other way that I give someone else rights to use my work is not through permanently transferring it through assignment, but through a license, kind of thing we were saying in your company scenario. So I like to think of copyrights as being a bundle of rights, and we can divide up that bundle in all kinds of ways. So it could be that I want to license you the translation right, and I want to license to you the right to take a chapter and distribute it broadly. And I want to give you the right to build an app based on it. And in your case, I only want you to have translation right for 10 years. But the app, I'll let it go forever. And in some cases, maybe I want to develop an app that I will sell. In other cases, I might want to just make it available freely. So it could be for free, it could be for a fee, or maybe you pay me a royalty based on what you earn on those translations. It can be limited in time, or it can be forever. You can, as many ways as you can think of it, you can divide those out. And as the copyright holder, you control all of that. Now, technically, licenses do not have to be in writing the way assignments do. But as soon as you start to think about how you would enforce anything like this, if I said I gave you a 10-year translation right with 10% royalties, and we don't write that down, you're asking for trouble. So I always say, try to put these things in writing, because you need to have a meeting of the minds to have an agreement, and then there's no confusion down the road when people try to remember what they agreed to. Okay. Copyright notice. So you've probably all seen this in a book. It's the creator's name, the year, copyright. It says all rights reserved. What does that mean? Why do we do that? So the reason you do this is I'm now putting the world on notice. If I publish this book and I distribute it, I want people to know I'm asserting my copyright in that. I don't want everybody copying this. If I put it online, I'm not just putting it there for the taking. So all the rights reserved is I'm holding all those rights until and unless I give somebody permission. Where can you put it? Anywhere. Books, articles, PowerPoints, class materials. I often encourage faculty members, because I think, when you live in a world where everything's available on the internet, you often assume you can take anything, copy it, post it. That's technically an illegal copying. You take your professor's syllabus, copy it, and put it online. And I think when faculty put copyright notices and explain that to their students, it can lessen that confusion. So why bother? Well, first, as I said, put people on notice so they know you care about how and where your work gets used. It reduces the likelihood of infringement. It also makes it harder down the road for somebody to say, oh, I didn't know, it was an innocent mistake. Because once that notice is there, you're telling the world I'm asserting my rights. And then if they do it anyway, that's what's called willful infringement. It's like, I'm going to do it regardless. And that has an effect later on the penalties. Now, the copyright notice, I can put anywhere. As soon as I've created a work and I've fixed it, I can put my notice on. Registration is a little different. Under United States copyright law, and everything I've been talking about here is in the U.S. copyright law. It does vary a little by country. In the United States, if you register your copyright, then if there's ever an issue of infringement and you want to enforce it, you want to go to court or you want to sue somebody or send a letter or telling them to knock it off, you've established your priority rights in that copyright. And then, if they try to say, well, I didn't know, I'll say, look, I have a registration from 2018. Clearly, I'm the owner. You have to now prove why that's not infringement. Shifts the burden of proof to the defendant. It's cheap. It's $55 one time. You don't have to renew it. They took that out of the copyright law. No more renewal necessary. The other thing is you can't sue in the United States unless you've registered. So there's not much good in a copyright if you can't enforce it in court. That is only here. In other countries, you don't have to register in order to sue. But under the United States law, you still have to register. And somebody asked earlier, do I need to register in other countries to get protection? Or the answer is that under a treaty that the United States is in called the Berne Convention, if I own a copyright here, it will be enforced in any other country that's part of that treaty. So if somebody infringes me in France, I don't have to have a separate protection there. I'm protected because it's owned here. Another good reason to register is if you go to court and you prevail, you might be able to get them to pay your attorney's fees, and those can get high. I've put up here some of the screenshots from the Copyright Office portal, just because it's a very old and clunky interface, and I don't want you to get there and think you're on the wrong page because it looks so awful, because it's really just a bad design that desperately needs updating. But you'll go through the portal, you'll create a username, and that's what your screen will look like, and it won't be pretty, but you're on the right page. Okay, so, yes?
What level should faculty copyright their work in terms of a content management system? For example, every material that I create, or should it just be a specific class code, or should it be everything that should copyright? I don't want to have to pay $55 for each thing that I create, or should I just do one blanket for the whole thing, like for the whole one management system? Everything in that sort is possible.
Yeah, it's a great question, because it is inexpensive, but it does add up and it can be time consuming. Well, two things. One is something like a website can be a one-time registration, which will cover all the pages of the website and the code underneath it. Second, I would say, for example, if you want to publish a book, before you start sending the manuscript out, is a good time to register it as an unpublished work, because that's when you increase the likelihood somebody might get hold of it and infringe it. As far as course materials, I mean, I think reality is most faculty don't register it, because how likely are you to really want to take legal action on that? But if you're thinking of putting it into a book, if it's going to be put in an online course, if it's going to be widely distributed, I would say minimally put the copyright notice on it. And the thing is, if it's infringed and it's not registered, you could still try to register it right then, but then you would only be able to recover going forward from the date of registration. So you would kind of lose the protection going back. So it's kind of a risk analysis of how likely is infringement and how harmful would it be to you if it was infringed. And just a little side note on that, copyright registration can take anywhere from 6 to 12 months because the Copyright Office is very backlogged. There is a case pending in the Supreme Court that's going to determine whether you can sue from the date you apply to register or when the registration issued. So right now we don't know because the court's going to decide that. The recoverable damages in copyright violations, is actual harm, commercial harm that you can show, lost sales of your work, say. For a lot of copyrighted works, you might never earn anything on them. And so we have other ways of protecting creators, which is that if you've registered your work and you're suing, you could recover between $750 and $30,000 for each work that's violated. And obviously that's a lot more if you have the kind of work that most copyrighted works are that don't make money. The other thing is, the reality is most people don't go to court, but what is powerful is if you have a registration and can send somebody a letter and say, look, you violated my work, I have the evidence, here's the registration number, I will sue you for statutory damages, so you need to just pay me $10,000 and I'll go away. The people who do this best, I know, are photographers. They're very there's nothing, you're not going to prevail here. So that's why it's so powerful. So how do you prove infringement? Two elements. First, you need to show the infringer could access the work. If you've had your great novel sitting in your desk drawer all this time and nobody's ever seen it, even if somebody comes up with the exact same idea and puts it out there, if you can't show they could possibly have seen it, then you can't show that they infringed it. That one's fairly easy to show. Second is substantial similarity. You have to show there's really enough similarity between their work and your work that it's clear they were copying your work when they made it. And this sounds like it's pretty easy to prove, but it actually can be somewhat difficult to tease out what are the protectable parts. Because first of all, you may have other people's materials mixed in with your work. I may have images from someone else in there. If that's what somebody copied, I can't sue them for infringement because they didn't copy my work. They copied the person whose work I was using with permission. The other thing is, as we talked about, there's no protection for facts. So if they're copying factual information from my book that I didn't really add creativity to, that's not infringement. And then there's certain sort of stock elements, like the Romeo and Juliet idea of these star-crossed lovers, young teenagers from warring families. That's a common dramatic idea. If I come up with some variant of that, Shakespeare's in the public domain, but for example, West Side Story was a musical in the 60s based on that same idea. These two, teenagers in love from warring gangs in New York. Well, that was using that idea, but if I come up with a play based on two warring gangs in New York and the two teenagers fall in love, that's pretty obviously now I'm copying West Side Story. All right. Okay. So if somebody is sued for infringement, we want to think about what are the defenses that somebody might have. Because you all probably use a lot of materials in your day-to-day life, in your academic work. And you don't want to be facing suits for infringement all the time. But there are a lot of defenses built into this. And we're going to go through all of these. The biggest one is fair use. So important thing to know is like these others, it's a defense to infringement. I don't just walk around saying fair use, I'm doing this as fair use. It's if you are sued or somebody accuses you of infringement, you say, no, it's not infringement because it was fair use. What is fair use? The idea behind it is that copyrights give their owners a monopoly on their works for their life plus 70 years. And we do that because we want to encourage people to create works. And if we took all their rights away right away, it might discourage people from creating books and plays and apps and all these things. On the flip side, under the First Amendment, we want to protect free speech. We want to protect criticism and commentary and parody and building on other people's scholarship. And you have to somewhat use their works to be able to do those things. So we hit that balance between copyright and a monopoly and the First Amendment with the concept of fair use, which protects these kinds of things. So under fair use, to determine whether the use you're making would be considered fair use and therefore non-infringement, you have to walk through this 4-factor test. We'll walk through these one by one. But I wanted to show you this. This here is a sort of classic example that was a real case in the last decade or two. So President Obama, on the left is a photograph that was taken by a news reporter, a news photographer, I think for the Reuters or the Reuters press. So basically he went to photograph Obama at a conference that he was attending, and this basically documents that President Obama was there. That's why he took the photo, that's what it was used for in the newspaper. On the right inform people in the news that President Obama attended this conference. The purpose of this now is changed to be this inspirational image of the candidate. So if you can show that a work is transformative in that way, and you can see, right, if you're thinking about it, well, when is it a derivative work, and when is it a transformative work? And I'll tell you, the courts wrangle with that question a lot, and it's not always so obvious, but that's the question they're asking. Another thing that's protected is parody. You see, Michael Jackson came out with Bad. Weird Al Yankovic is probably the most famous parodyist. He came out with Fat. He took the same song. He changed the lyrics. He's making fun of the original song. Parody is arguably a kind of commentary or criticism. Again, we want to encourage it. It's free speech. It's healthy in a democracy to have lots of parody and commentary. Now, if you're trying to figure out, that can start to feel very difficult. It's like you can say it easily, purpose and character of the use, but to try to understand it and apply it can be difficult. So sometimes it's easier to look at what's not fair use. And arguably, if you haven't changed the purpose, if the original purpose was, say, to be a news photograph, and then I keep using it in a different news setting, then I haven't transformed the purpose. If Michael Jackson was meant to entertain, but Weird Al is now intended to parody, they're doing something different with it. But if you're purely profiting commercially and you haven't really changed the work, that's a red flag to the court that you're just trying to capitalize on somebody else's creative work. So the more you're profiting from it versus nonprofit educational scholarship, the more it's going to skew towards not fair use. All right. Could you go back one slide?
So I'm a little bit confused. Let's see here. You're saying the purpose of Michael Jackson, his Bad album, was for entertainment, and then Weird Al's was for entertainment as well. So can you describe about that? I'm confused. I'm not sure.
Yeah, it is confusing. And if somebody had just recorded Bad, the same song, and put it out there commercially without permission, then that would be purely entertainment. It would not be transforming it in any way. The reason Weird Al is okay is because he's not just recording and entertaining the same way, he's making a parody. And it's a great question because everybody tries to make some money off of what they're doing. But if you're really using somebody's work, you're not adding anything creative to it to make money, that's going to push back on fair use. So I might write a book, I hope it'll sell. But the reason I'm writing a book and commenting on a song is not to cash in on that song. It's to say something else about it.
Got it. Thank you.
Okay. The second factor we look at is the nature of the work used. The more it's factual, nonfiction, less creative, that will favor fair use. Because again, there's less protection, we talked earlier, for things that are factual or scientific in nature. So if that's what dominates in that work, it's going to favor a finding of fair use. On the flip side, if it's a very creative work, then and you're using that, that's going to disfavor fair use. You will more likely need permission for that. The amount used. What favors fair use is a small amount. If I want to write about a book and I reproduce 3/4 of the book, that's not very defensible. So you want to copy small amounts and really just copy what you need. If I want to make a commentary about, a poem and it's 14 stanzas long, if I'm really just talking about one stanza, I just reproduce that stanza, not the whole thing. And it should be, it's obviously in proportion to the work, how big the work is. And a small amount, it's easier to understand that concept of a book, right? But if we're talking about a photograph, you can't take part of a photograph, right? That doesn't make sense. Arguably there, a small amount would be like a low resolution, small photograph. So you're not impairing the market for large, high quality versions of that work. And the other issue with the amount is it matters what part you're taking. So something like Bob Woodward's Fear book about the Trump administration, if I'm a journalist and I just copy the best parts and put them in an article and a review, such that people are like, I have to buy the book because I got the best parts in this article, that's going to be not fair use. There was a lawsuit about this with the former president's biography, where it was all about Gerald Ford, and everybody copied just why he pardoned Nixon, and nobody bothered to buy the book. And so he sued and said, even though you only copied a small amount, you copied the part that was going to make people buy the book. And then the last factor is the effect on the market. If there's a ready market for balance these four factors. What matters most? And unfortunately, there's no bright line rule. Courts use what they call a balancing test. Different kinds of cases with different kinds of works, they will balance those four factors differently. So there's not one hard rule I can point you to say what's definitely fair use, because it's going to vary based on the case. The best thing I can tell you is it's important to try. Even if you get it wrong, it's important to try. And the reason is that if you are an employee of a nonprofit educational institution, like a university, and you use something and you reasonably thought it was fair use, a court will not assess statutory damages in that case. You can show you used it and thought it was fair use. And so I always encourage people, even if this seems so impossible to kind of go through this analysis and these courts are not clear on the guidelines, just try to get them down, try to write it down, and then if you're ever questioned, say, look, this is what I was thinking, why I thought it was fair to use. And if I'm wrong, I apologize, but at least then you're not going to be facing $30,000 in damages. Okay. Quickly, I want to touch on the Digital Millennium Copyright Act. So the DMCA was an amendment to the copyright law that went into effect in 2000. And I will tell you, it was already out of date when it passed into law. That's how the pace of Congress keeps up with technology. The most important thing is that if you try to circumvent digital rights protection, like if you try to rip content off of a DVD in violation of the protection that's on there, there's no fair use defense for that. That is a straight up copyright violation. There are some limited exemptions for film studies programs that somebody lobbied for, but basically you can't get around that. The second thing is it created this, what's called a safe harbor for ISPs, internet service providers, like Google, YouTube, Facebook. So much content gets posted to these kinds of sites that they can't possibly monitor it all. And so infringing works are likely to get posted there. And they said if we are liable for contributory infringement, for helping to infringe whenever somebody posts something illegal, we're going to go out of business in no time. And we wanted, again, it's a policy decision. They wanted to encourage the use of these kinds of YouTube, of Google. So they said to the ISPs, as long as you have a mechanism that if somebody complains about infringement and you take it down, we're not going to hold you liable for contributing to that infringement by creating this place where people could infringe. Okay. All right. I'm going to touch briefly on Creative Commons, because I think a lot of people have heard about this, especially it grew out of kind of software developers who were eager to share their works, their code. It's a lot of the culture of Silicon Valley that they want to share and build on each other's works. So the idea is they wanted to basically make it available publicly, but it's not the exact same as public domain. Remember we talked about public domain is just when a work falls out of copyright protection. Things that are licensed under Creative Commons are still protected by copyright, they're just being made available on a very broad license. So if you go to the Creative Commons website, there are different levels of licenses you can pick to apply to your work. So some people might say, I just want to put it out there, I don't care what anybody does with it, take it and run with it. And that's the broadest license you can put out. Some might say, fine if you want to use it, but only for nonprofit reasons. I don't want somebody commercializing this software that I really just put out there for the good of humanity. Or you might say, I'm okay with you using it, I don't care if it's commercial or not, but I want attribution. I want my name to be tied to it so people give me proper credit for it. And if you'll notice, all the images I was using in the PowerPoint had little attribution lines. They were all Creative Commons licenses that I found online. And so those Creative Commons attributions came with the images when I put them into the PowerPoint. Now arguably, I could have not done that, because there's something called the face-to-face teaching exception. Oops. So, in a setting like this, where I'm teaching you something, there's a kind of broad protection to use copyrighted works. Kind of goes back to the PowerPoint of the art teacher, right? You're allowed to do this in the classroom setting. There's some restrictions that you see here. It's only to be used by the teachers or students. We have to be physically in the same place, like we are here, and you're really teaching. So this is not, if we shut this down and we start broadcasting a film in here for everybody afterwards and we put out popcorn, that's not the face-to-face teaching exception. Now we're just showing a movie. And it has to be, again, it has to be from the face-to-face teaching exception that I just caution you to tread carefully because it's stricter about how much you can use and in what context. So I would say if you're going to do it, do a little research to make sure you understand what the rules are regarding the Teach Act. And just to be clear, it's only for online courses. It's not for something like Blackboard or CMS that complements an in-person class. And there's a reference here. If you Google the Teach Act North Carolina, you can find good guidance on that. And these slides will be made available to everybody afterwards. So I just want to leave you all now with the reason we're doing this here today is because Gallaudet is beginning a process of coming up with its own IP policy. And so here are some questions we want you all to consider.
No, we've got about 3 to 5 minutes left. Does anybody want to ask any questions? I know this is just the beginning of a series. We'll have more in-depth discussions in the future because it's time for Gallaudet to be ahead of its game. We have a lot to offer the world as a unique university, as a unique access to visual language, discovery, etc. So it's really important that we're prepared. And as we create and develop our intellectual property policies, specifically, so I'm Tracy Sullivan. I'm teaching this GSR 300 course. Our students are developing a timeline, an interactive timeline, including video. That video is fair use, for example. Deviant, Deaf President Now, was uploaded to YouTube, so we're using those YouTube videos. And then copying the QR code to make it interactive where you can scan the QR code with the phone. So that's kind of the idea of what I'm talking about. And I'm wondering, does that film, which is a 9-minute long film, if we were going to clip a segment, a 2 or 3 minute segment of that, is that considered fair use? Do we need to acknowledge the purpose that is for public learning, or public learning program, or something like that? How would you define that in terms of a public space that Gallaudet University uses only, and what's the best way to approach that?
Do we have another hour? There's so much wrapped up in that question. First, you want to think about who all is contributing to this, all the students that are involved here. Are we all going to consider ourselves joint authors of this work and joint owners? That's kind of the first level. And if there's an idea that you want it to be owned by the university or something, then it's the students agreeing to sign over rights or at least permissions for that purpose. If you're accessing content on YouTube, that is obviously copyright protected. It kind of depends on the level of transformation you're doing and the purpose, and that's where you want to walk through that fair use analysis. If you are merely linking to content on YouTube, that's just directing people to an address, so that's always fine, and that's often a good workaround. You don't want to copy things, but you want to get people to see them, is you just provide a link to it, which is not really to answer your question, except I think it's useful in other contexts. But if you are taking it and you are trying to manipulate it and change it or add things to it, it sounds like it arguably is a transformative work, and the fact that it's done in an educational context for a teaching purpose sounds to me like it's a very strong fair use. Now that being said, its creation sounds like it's probably fair use, the project, the copying. If you then go to post it somewhere and distribute it, you just want to make sure that's exercising another right. And if that arguably the creator of the underlying work would say, well, now you're harming the market for my work, then you might have a problem. So there's different steps of the analysis and the creation, and then distribution is really a separate question. So a lot of things you can do on campus in classrooms as collaborative learning projects are fine. It's often the problems that arise when people put them back up online. I mean, I've dealt with a university where they wanted to do this wonderful student performance where they filmed lots of different departments all lip syncing to a Lady Gaga song, which is a great learning experience, but once you post it, she might have issues with that. So that's where you have to be careful, and that's where you might need permissions once you start trying to post it online and publicly distribute it. And frankly, that's where it goes above the radar. As long as you keep it internal, people won't know about it. Once you go public, it's findable. And on the internet in a way it never was.
one situation that I have of one artwork by a very famous artist that Gallaudet purchased, who Gallaudet owns. And there was an agreement that I could change it to derivative work and use that artwork to become a digital image, and from that I could make a poster PowerPoint.
Yeah, I mean, if you have an agreement that gives you that right, that kind of agreement will always trump what is in the Copyright Act. That's why license agreements are so important, because whatever the copyright law provides, that's the default position, but you can always enter an agreement. So it sounds like they gave the physical work to the university, and that's great, but that's actually a great point, is that when you convey the physical work, you're not necessarily conveying copyright with it. So the artist has to also give you rights to use the copyright to make posters and derivative works from it. I don't know if that answers your question.
I think that's a problem. To tie into your question, it's a very important discussion because for me, I thought that a person creates a painting and then sells it. I thought it would include the COA, Certification of Authenticity. You heard that phrase before, the COA?
Yeah.
So a COA is included, and attached to the painting. So if Gallaudet were to copy that picture for publication, posters, etc., they ask the author for permission and lets them know, hey, we're planning on copying this picture, use for posters, etc. So I think the author has to know what the purpose is for. Am I right or wrong?
That's right. Yeah, I mean, the certificate of authenticity is not the same as a copyright transfer or assignment. So if you are only giving somebody the painting, unless you are conveying in writing the copyright in the work, the right to make copies, derivative works, those don't go with the physical work. And so you would have to get special permissions. Or, I mean, what often the libraries do is if they're going, or museums, if they're going to accept a work as a donation, the donor, or the artist, has to convey all rights, all copyright. And you put that language right in the gift agreement, so it's clear the university is getting everything, both the physical work and the copyright in the work.
Any other questions? I think you guys have one more question.
So you said about the material, media, and the express.
One second, we're actually starting to listen to come back to you. Sorry about that. Sorry, get a little conflicted here. I have a question and a comment too. So specifically to copyright, I think for establishing policies here, it's nice if we had, some of the universities that we could get understanding of what kind of incentives could be in place for people who are innovative. My understanding is those who work for hire, I know that I'm hired for my work, that means anything that I do is delivered to the university, or the university will own it. For example, it's a different situation for students. Students are studying. They're paying to go to university, so students have their own rights. So people who do innovative work and are receiving creative ideas, I think that it needs to be a clear place of trust, and feel motivated to create, and not feel like, I have to contain my ideas and keep it safe. University needs to find a good policy and good balance. I think that it's free to be creative and free to have that comfortable collaboration. So hopefully, I've seen different ideas if universities have good practices, but I think that we should find those and be able to learn from them. I think that's something that I should put on the table.
If I can follow up on that, I've worked with various universities on developing intellectual property policies, and the best ones come out of a process where we make sure everybody who has an interest is at the table, the students, faculty, staff, and particularly library staff. And if you have a university press, get them involved, because libraries are often the repositories of copyright knowledge at the university. And also, the best policies are not trying to reinvent the wheel. I mean, universities have usually functioned mostly very well on these types of things, and so often what we're trying to do is figure out what you're already doing and then capture that in the policy. you know, it often is driven because people are doing these outside collaborations with companies. And one of the first things a company will say is, well, what's the university IP policy? Or you have, you know, your office I forget the name of it, but where you're collaborating with outside companies, they want to see an IP policy. They're used to seeing them. So they want to make sure, so that's what's driving you to adopt it, is because you want to encourage those kinds of collaborations.
I definitely agree. We do have to find a happy medium that actually encourages that innovation and gives that incentive to create partnerships, to create monetary ideas. And I think that happy medium is something we can find balance for. And we can definitely have a conversation about that. Did you have a final question?
Yes, quick one. So I just wanted to ask you about copyright on the internet. The things about things on the internet, such as the forum. You write on forum or sometimes ebook or blogs.
Yep.
Can they be claimed? Can copyright be claimed on those things?
So usually if you are posting something in an online forum or a blog, if you actually look at the terms of use on that page, they will say basically anything you post here, either you're conveying ownership or you're giving me a license to use it and reproduce it on my blog. So that's where terms of use that most people never read are actually quite important because they set the terms of how people are providing content on those
Depending on
pages.
each forum or each blog.
Yeah, I mean, once you put it there, you should assume people will feel they can access it. You're essentially giving an implied license to others when you put it in that kind of setting. I mean, yeah, if you comment in a forum, and you could try putting a copyright notice on it, but I wouldn't recommend it. And I'm happy to stay for any questions if people want to follow up.
Okay, thank you for coming out, and I hope you have a safe trip back, and this is not the last time we're having a conversation, there's more to come. It's 3:10 now, so I would like to let you know that it's very important, and I really want to, have a process to encourage creativity, plus protect yourselves and protect the university, and really want to make a showcase of your beautiful work to contribute to the world. So I'm trying to see a win-win for everyone and for all. So thank you again, and we will be able to share the PowerPoint with everyone today. We can send it out to your office, and I think that's all. Thank you again very much.